Tracy and I are really excited to speak with you today. With the continued rise of artificial intelligence and machine learning, particularly in the digital health space, we're going to try and provide you with a brief primer on some hot issues regarding data privacy laws and compliance strategies as it relates to such AI/ML use. By way of some additional brief background, I'm a senior associate out of DLA Piper's New York City office in our healthcare regulatory practice. I focus my practice on assisting digital health companies with a full range of healthcare regulatory matters, including HIPAA and other healthcare regulatory considerations regarding the use of artificial intelligence and machine learning, both within healthcare and life sciences companies. I'll now turn it over to my partner, Tracy.
Thanks, Dan, and good morning, everyone. So I am a healthcare regulatory partner with our Washington, D.C. office of DLA. And my practice, like Dan's, focuses on HIPAA and healthcare data privacy, as well as regulatory matters relating to a range of issues, including payment for healthcare products and services. And in that, I work with all types of healthcare providers and suppliers, as well as the companies that provide products and services to those healthcare providers and suppliers. And this, of course, includes working with digital health platforms and the solutions they provide. So today, Dan and I have structured this session as really an informal Q&A where we'll be asking each other questions back and forth. So I'll get us kicked off here with our first question, and this one's to Dan, of course. So Dan, where do you see the biggest gaps in current U.S. data privacy regulation as it relates to digital health and AI and machine learning?
Thanks, Tracy. At the outset, I think it's important to note that while artificial intelligence and machine learning have been buzzwords for the last couple of years, particularly with the advancements of generative AI, the idea that we have AI and ML models is not in and of itself new. Additionally, I want to note that a lot of technology these days is labeling itself as artificial intelligence when really it's just acting as software. So currently, there are laws both on the federal and state levels that are already being adapted to AI and ML use cases. So we have HIPAA, which is obviously a topic that we're going to be discussing today. There's also Federal Trade Commission enforcement on the federal level that kind of enforce the algorithmic use and disgorgement if you don't have the proper consent. But one gap that we see in the healthcare context is that while HIPAA has a definition for what constitutes de-identified health information, there isn't necessarily a uniform definition that can be used in all contexts outside of HIPAA. And we often see de-identification and anonymization used interchangeably within the industry. However, these days it's really difficult for information to truly remain anonymous, particularly when you kind of combine data sets with one another. All of a sudden, you're now linking patient data together, and you might see that the information that you thought was quote unquote anonymous is not actually anonymous. Outside of HIPAA, there's a patchwork of state consumer privacy laws that also make it potentially difficult to train and develop your artificial intelligence and machine learning models utilizing consumer health information. So given some of these gaps, what we're kind of expecting to see is states continue to take legislative action to try and regulate both the AI and ML model use, also regulating the privacy and security of those models, and then the data inputs that train such models. We probably will expect to see activity in more highly regulated states, including California and New York, and then other states kind of follow. So you look at the CCPA was the first preeminent law, then other states kind of followed suit with Washington, Nevada, and others. With regarding artificial intelligence in particular in healthcare, state laws are starting to develop and percolate, but for now they've been industry specific. So the use of AI in employment and insurance contexts or within the financial sector. But we expect to see kind of more laws develop regarding bias testing and other sorts of healthcare specific use cases regarding AI. Tracy, anything to add to that?
Yeah, I would just add, and we're going to touch on this in a few moments, but just in the context of the legislation that you mentioned, I think, the other place where just as a component of all of this, where I think that the legislation may touch upon is on consent and how you can get meaningful consent in this context. But that's foreshadowing a question to come.
Thanks, Tracy. So Tracy, next question for you is, what privacy and compliance strategies should early stage digital health startups prioritize when using patient data and AI tools?
Yeah, thanks, Dan. It's a great question, and it's a really important topic for startups and really any business that's trying to develop a solution. And it's often the case that startups are under pressure to develop and monetize that digital service as quickly as feasible. And, but addressing privacy and compliance considerations on the front end can really create substantial efficiencies down the road. And it also provides sort of a more insightful path, I think, to the business and really what you're doing with the data and the like. When privacy and compliance are not considered, sort of the flip side of this out of the gate, there can be a need later on to retool or re-engineer components of the services, which is not always a desirable or costly situation or cost efficient situation. So for this reason, we think it's often helpful for digital health startups to consider, as they're developing their solution, a real privacy by design, security by design approach in the original build out. As part of considering privacy and security at the outset, this involves developing a working understanding, at least, or working with consultants and others on what the data rights laws are within the jurisdictions where the services will be offered. That understanding will help to drive part of the developmental decisions for the solution regarding the use cases of data, and also when consents are provided, how they will be maintained, whether, and importantly, whether data need to be segregated in some way within the environment to ensure compliance with the consents that may have been obtained or will be obtained, and with the data rights laws that apply to the solution and services. In addition, and because we're talking about healthcare startups here, it's always important to mention HIPAA. And just as an aside, for those that are not totally familiar, HIPAA is our federal healthcare privacy law that applies to covered entities and business associates. Covered entities are most healthcare providers and health plans, and business associates are the vendors and service providers that furnish services to those covered entities that involve protected health information. And really, HIPAA is a federal baseline, or provides a federal baseline of privacy protections for protected health information. When it comes to privacy issues, the general structure of HIPAA is that if a use or disclosure is not expressly permitted by the law, then the use or disclosure is prohibited. And the law also provides a baseline of security standards that need to be applied or addressed with respect to the information systems that maintain PHI. So I mention all of that because if the service that the startup is providing is going to be targeting customers that are HIPAA regulated entities, it's really important to understand at the outset that there are material limitations from the regulation and prohibitions on how protected health information can be used. And that, is, can you use protected health information in your AI and ML systems? What are the permissions that you need to obtain with respect to derivative data sets, such as de-identified data, for the use in AI and ML systems? That really needs to be evaluated, and those permissions need to be sought contractually. So, for example, if a startup is going to be a business associate under HIPAA providing a service to a HIPAA regulated entity, the startup would need to have the right to utilize or leverage the customer's data in a de-identified form to build out their AI or ML model. They can't do that unless it's explicitly provided in the agreements. And that can be a challenge for startup companies trying to gain business, trying to expand their business portfolio, and trying to also improve their products. And in this regard, data segregation can become critically important. And as a last point here, I would just note that data is, particularly in the healthcare space, is seen as an asset. It is increasingly seen as an asset. And health systems and other kinds of healthcare providers and suppliers are taking much more aggressive stances on what they will allow with respect to the data that they have custody over and are charged with protecting. And so they're often not allowing the use of patient information or even de-identified data sets for purposes other than the provision of the actual service. And so it can be challenging to gain further rights for the use of data in AI and ML solutions. Dan, did you have anything else you wanted to add there?
Yeah, I think that's super helpful, Tracy. The one thing I would add is if you were trying to leverage other AI or ML tools within your organization, I think two important points. One would be to make sure that if you're a business associate, that you have the right business associate subcontractor agreement in place with those vendors. And then the other point would be to train your employees so they understand how to use leverage and use those tools effectively, but also in compliance with whatever data privacy laws apply to your organization. As Tracy touched upon this earlier, we want to talk a little bit about patient consent. So, Tracy, how can we ensure that patient consent is truly informed when data is going to be reused to train AI systems?
Yeah, thanks, Dan. This is a little bit of a challenging question. And really, to answer the question, we should first talk about what the underlying concern is with patient consent and AI. And the issue really stems from the evolving nature of AI systems. That evolving nature can mean that the use cases may not be fully understood, sort of future use cases may not be fully understood or even anticipated or known when the consent is actually obtained. So this in turn can create sort of a conundrum of whether the consent obtained is meaningful when it was obtained and whether it remains meaningful over time. So in general, the idea is that you want to develop a robust, transparent, and adequate consent that is also simple and easily understood. Those things sometimes don't go well together, simplicity and robustness. And that all of that coming together is the intent is to provide the data subject with an informed decision making, a tool for making an informed decision about what they're going to allow for the uses of their data. And this can be challenging. So we think that, as we noted, this area is evolving, is likely to evolve, and we anticipate legislation here may result and promote more robust protections over time. So in general, we would just note that there may be some general guideposts here that you may want to draft your consents as broadly as possible and provide for the fact that AI systems and use cases are evolving over time. And you may need to revisit consents as the AI systems evolve. Dan?
Just to close out, because I see we're at time, I think a closing and parting thought is to emphasize the need for cross-disciplinary collaboration when you're kind of working with AI and ML. So you want to make sure that you're not siloing your departments internally, but rather bringing together your technical teams, security teams, business teams, and legal teams. And together you kind of create an AI governance strategy to make sure that you're adopting AI and ML in the appropriate and compliant way. Thank you, everybody.
Thank you, everyone.